Hello, my name is Afiq Izhan Shafiq bin Imran Hazali and I am living in Bani, Selangor. I'm currently in law school, which is at Uniza Terengganu, and if I'm being honest, I started from the bottom and I'm very proud that I made it here. I didn't get good grades for my SPM and later on I took STPM and worked really hard before getting here. So, what inspires me to become a lawyer in the future is honestly, I really needed the money in order to secure a good future for my family, friends, and those who mean the most to me. Aside from the money, I aspire to be a lawyer ever since I was a kid because I grew up in a family filled with lawyers, which gave me an insight to the scene. I honestly would like to make the world a better place. In other words, I would like to be the person who is there to keep people safe even if the odds are against them. My father once said that if there are no good people in the world, you just have to be one. Therefore, I will be that good person who defend those who are in need. So, now I wish to give my legal opinion with respect to the legal issue that arises out of the Movement Control Order or MCO imposed by the Malaysian government to contain the spread of the COVID-19 by creating a multitude of legal issues for businesses. I truly believe that the MCO could not cause a breach of contract. A breach of contract is when one party in a binding agreement fails to deliver according to the terms of the agreement. There are a few elements required in order to establish a valid contract, and those are offer, mutuality, consideration, and acceptance. In order to convert a proposal into a promise, the acceptance must be absolute and unqualified. Then, the acceptance must also be expressed in a reasonable manner unless the proposal prescribes the manner in which it is to be accepted. If the proposal prescribes a manner in which it is to be accepted and the acceptance is not made in that manner, the proposal may, within a reasonable time after the acceptance is communicated to him, insist that his proposal shall be accepted in the prescribed manner and not otherwise. But if he fails to do so, he accepts the acceptance. In the early year of 2020, a global pandemic broke out which had a very big impact for the people, especially those who are in businesses, since it disrupts the business rights under and obligations under contract are coming into the center of attention. Therefore, I believe both the provision that was found on COVID Act 2020 and force majeure clause can be applied in the agreements. Force majeure clauses will be generally adopt one of the following approaches to define the type of event which may, depending on its impact, relieve a party from contractual liability, which is listing specific event where the term pandemic is included. The term clearly covers the issue that arises COVID-19. Because of the problems caused by the global pandemic, the COVID Act 2020 was introduced last year, where it stated that the complainant will not be entitled to exercise their rights under the contract even if the accused is unable to perform their obligations pursuant. This can be referred to as mentioned in the Prevention and Control of Infectious Disease Act 1988. Then, I would like to give an info about force majeure, where it is a contractual clause that alter parties' obligations under a contract where an unavoidable event beyond one's control prevent them from fulfilling these obligations. When it comes to an agreement, the essence of time is very important. I strongly believe we really need to have a clause from the time essence to be included in the contract. A solution for this issue would be to provide a clause where both parties will have to agree that the completion of time for the contract is to be extended because of the MCO, since it is very hard for people to even meet up amidst the pandemic. There has to be a requirement where the parties can include a clause where it says, time whenever mentioned shall be of the essence of this agreement. A prime example to illustrate the importance of time essence is, when it comes to a sales and purchase agreement, there is a condition where it has to be paid within 3 months from the date of the agreement. But if the bank is to give him a loan, There are a few requirements before they can do so. The buyer needs to register first at the land office. But due to the pandemic, the land office is closed. If the land office is closed, the time will inevitably be extended. Therefore, due to the COVID Act 2020, there will be no breach of contract. So in conclusion, with the essence of time, the COVID Act 2020 as well as force majeure, I stand with the movement control order could not breach a contract, as it can be considered as an unavoidable event due to COVID-19. This is also because when the government announced the MCO, not all sectors of the businesses and the government are allowed to be open for operations. Therefore, it is unnecessary for a contract to be breached because of the MCO, as it is an unforeseeable event which no one could expect for the event to happen. With the essence of time, we could provide parties more time for them to be done by the extended completion date. So yeah, that is all from me. This is my sister. Thank you so much. Bye bye.
Bye bye.